Welcome, everybody. Welcome. So, I was watching the Bryan Kohberger hearing, and I'm just going to jump in to someone else's feed here. I thought my head was going to explode, honestly. So, if you want to follow along while I watch it, I watched like halfway and then I stopped because I was just sort of blurting out expletives as I was watching it. And I thought, well, I'll just record it and see what other people think if they want to check it out with me. So let's have a look.
Cited. Subparts K through M deal with the names of private citizens who were interviewed, and disclosure would constitute an unwarranted invasion of personal privacy, subject to 74-104 subsection C. It could contain intimate facts or statements of which would be highly objectionable to a reasonable person, exempt under Rule 32 I-2A, or invoke traditional legal concepts in the law of the right to a fair trial, invasion of privacy, under Rule 32, subsection 3. Subpart N through O is exempt under interfering with enforcement proceeding, depriving the defendant to a fair trial, as well as disclosing investigative techniques or procedures. Item 2, subpart A, names a private business, and is exempt under the previously cited authority. Item 2, subpart B through L, deals with the investigation. Again, exempt under 74-124A, subsection B and E, as well as Rule 32, subsection E.
Right now.
Item 3 names multiple private businesses.
Like usual.
It's also exempt under the same subsection, 74-124A, B, E, C, as well as Rule 32-12A and 3. Subpart I deals with the investigation, exempt under those same authorities. Subpart J
It looks like
involves a private citizen
on the defense side.
exempt under those same authorities.
That's just
Subpart K through B deals with the investigation and is exempt under those same authorities. Item 4 deals with IGG information, which has been sealed and is under a protective order from the court protecting its disclosure.
It's interesting. Nobody shows up to these courts.
If the court decides to open this hearing to the public,
right,
the state defense will be discussing evidence without any context. This will undoubtedly fuel speculation, lead to assumptions and false narratives.
Judge, wake up.
The evidence discussed may not even be offered, and most of it likely will not be offered by either party at trial because it's either not relevant or material. The public will not have any means or context to be able to differentiate.
Right, because the public were really.
It is necessary to mitigate this by closing the hearing in order to preserve the right to a fair trial for both parties. The defendant does have a right to a public trial,
Judge,
but that does not mean the right to try this case in media. The defendant will get his day in court, and the public will have a right to see what evidence the state has. But that should be evidence that is admissible pursuant to the Idaho Rules of Evidence. Now is not the time for that.
And doesn't want to give anybody.
We ask the court to grant the state's motion
to
close the hearing regarding the defendant's 4th and 5th motion to compel discovery. Lastly, I ask you to issue a scheduling order for the parties to disclose witnesses, exhibits, expert reports, or any other evidence they plan on relying on for those hearings.
When the defense
prior to the hearing, the state proposed May 3rd, and then a response to those by May 10th. And the state takes no issue with this being a dual deadline.
Oh, isn't that nice? Thank you, state.
Thank you. May 3rd might be a little quick.
Well, Your Honor,
Tomorrow.
right, but our motion was filed over a week ago.
Right.
So everyone's been on notice of what the state was asking for.
Okay, thank you. Thank you, Ms. Daniel. Ms. Taylor?
Thank you, Judge. Our discovery requests have been filed for months, and they've gone unanswered too. So if we want to talk about being on notice for something, we can talk about that.
Tell
Can I just add, because I've read through all of the
Uh-huh.
fourth and fifth, and it's, I mean, some of the information, it isn't, it seems anyway, I mean, I'm not,
taking sides.
it's hard to know, okay?
Uh-huh.
But it seems like the state has provided and has responded to some of those requests, and
But that's
some
important.
they're still waiting to get that information. So that's the impression I had. I don't know if you disagree with that or not.
Yeah, I think she does.
I would say the court is maybe in part right, but there's a lot of other parts to those fourth and fifth, and the court's referring to our motions to compel, not discovery requests themselves, but they do reference a number of discovery requests that have been going out. And we can talk specifically about each of those items.
I prefer not to.
Which is fine. I'm prepared to talk about why this needs to not be a closed proceeding today. But I don't agree that the state is completely responsive here. So I think the court can read and see that they say, we'll get it when you get it. I think the court can read and see when they say, we're not going to offer it, so we're not going to get it. I think the court can read all of those things, and we'll talk in depth on the 14th about what they mean and some of the ins and outs that go into play with those. But there's a lot more than just meets the eye. With regard to the hearing on the 14th, the state directs the court to look at Idaho Court Administrative Rule 32 and Idaho Code Title 74. And those really talk about documents that the court can seal. And both really are in, if you look at them, they are to talk about openness of the court and public's right to have information and what things the court can shield from the public and what the public has a right to know. And when we're talking about documents, it's been brought up that we've filed a lot of documents under seal. We have. Those are documents that end up in the public record that thousands of people can read. And we filed those under seal for expediency and saying, this is exactly what we want from discovery. If the court looks at the documents, and the court can and probably has through the year and a half this case has been pending, there are a lot of names and specific bits of information in there. And so for expediency, we filed those under seal, and for the reasons outlined in Idaho Court Administrative Rule 32. But what we're talking about now is a public hearing when the state has decided to not give us information or to drag their feet on giving us information. We're talking about a public hearing where we have a right to be in the public eye, a public hearing. Bryan's the one with the right. It's his Sixth Amendment right to have a public hearing.
Yes.
When the state wants to close a hearing, or any party, and the other party objects, which we do, the court is guided by case law in the state of Idaho and the backdrop of his Sixth Amendment right to a public trial in the United States Constitution and Article 1, Section 13 in the Idaho Constitution. So in the backdrop of that, the court is guided by case law. And the specific case, there's a couple of Idaho cases, State versus Kimbley and State versus Olivine, and they refer the court to Waller versus Georgia, and that is at 467 U.S. 39. And that puts forth the test that the court should look at when determining whether to close a hearing or leave it open and let it be a public hearing. And that the court has to find that there's an overriding interest that the hearing should be closed.
A lot of people.
In this case, in this hearing, that's not what's happening. The court would look at Bryan's rights here to a fair trial and balance that against the state's request to close the hearing. And we would want the court to consider this, that this isn't the state trying to protect Bryan's interests at all.
Not.
He has the right to the public hearing. This is the state trying to protect what the state's doing. And the court should look back through the history of this case. This is our fourth and fifth motion to compel. Motions to compel 1, 2, and 3 were public. They were right out in the open with the public. The specific discovery requests were also sealed. So this has been a pattern to do things in the public. And now this one needs to be sealed. The court has to ask itself why. And the court should ask itself, what is the state trying to hide here? The things that we're seeking
Bingo.
in these motions to compel are things that are outlined in the probable cause affidavit that has been public for a year and a half now, that has been offered to be shared far and wide. We're looking for things like videos that the state said they collected so that we don't look at things in a little vacuum. The state tells you not to take it out of context. That's what they're doing when they want us to do this in private and not let the state know about the full scope of the videos that are out there that they haven't given us. That is the state keeping things in a vacuum to control the public narrative.
Yep.
And that violates Mr. Kohberger's rights. That's what we want to prevent. This needs to be out in the open. Your Honor, I'll give you a couple of examples. The state filed last June its motion for protective order of the IgG materials. That motion was filed in public. It's on the public record. People can print that and read that and do all day long. And that had information that was negative about Mr. Kohberger.
They had no problem filing.
So that's out there in the public. But that order was to protect information, the IgG information, that they say details how the state got to Bryan in the first place. That's been sealed. That's fine. We respect that. But you have to question, why can we not talk about the things they're not giving us? Why can we not talk about the cell phone information, the tower information, the drive test information in a public arena? Why should Bryan have to have his case when he's asking for this information be done in a little vacuum where the state says what the public can hear and what the public can't hear? Another example of this, Your Honor, is with the video tape that they've relied a lot on in their probable cause affidavit that we've received different parts of. Part of the hearing on the 14th is to talk about the different parts of that video that we've received and how we need the whole context. This is the video that they say places this car near the residence. We've received little tiny pieces of that. And we think Bryan's right to a fair trial means the public needs to know that they've withheld the audio from a great portion of that, and that it starts a long time before the little clip that we've received. To do this in a vacuum, Judge, when documents are filed under seal, that's fine. Those are documents, but this hearing needs to be in the public eye. For the court to allow the prosecutor to say, we need to keep this all private for a fair trial, really ignores the public nature of this case. It really ignores the fact that Bryan has been essentially convicted in the media. You don't have to read but a few articles to see how negative they are about him. He has a right to have this information withheld, brought out in public, so that people can see it's not this neat little package. So people can start to wonder if Bryan's innocent. Your Honor, Bryan is innocent. And he has an absolute Sixth Amendment right to have his hearings in public. We think if the court allows the state to shield the information and how they got their information and what they don't want us to have from the public, they're using his Sixth Amendment rights to hide behind.
Sure are.
And that's just not what the court should allow. We strongly object to these kinds of things being closed.
Let's listen to what this.
Thank you, Ms. Taylor. You know, I don't know where does it stop though. I mean, if we start pulling out all the potential evidence for the trial before the trial, then does the state get to respond to that? And that's where does it start? I mean, it or stop. It just is a roll of that, and so either side, okay. It sends to the public that it is not, you don't get the context. They don't have the context.
We're not
public.
slow.
You have the context.
We
You want more
figured out.
context. I get that. But it's really difficult to just open that up and talk about particular issues in the case without talking about the entire.
No, I have to pause it for a second. This judge makes me insane. He's sitting there like floundering and like it's really difficult. And then once you start this, like, what are you going to do? Go back and forth? No, there's a law for it. There's a case law for it. And there's also his right under the Constitution. You don't have to go to Idaho, but if you want to go to Idaho, under the Constitution, he has a right to a public trial. And he's like, oh, but then if you start, you can go that. No, this is the first time you're trying to close a trial where they're compelling evidence. And you're worried because they're gonna show you, essentially, they arrested Bryan Kohberger. And then they gave a PCA to the public and painted him as a stalker, an incel, following people on social media. And the PCA was worded in such that people in mainstream media and the quote experts on mainstream media could get on there and run with its narrative. And everybody's like, yeah, he looks crazy. He's the one. The guy's been sitting in jail for 1.5 years. I don't know if he's innocent or guilty, but regardless, it's already, the damage has been done to his reputation. It's irreparable at this point. This woman has been trying to get their evidence that they say they have in the PCA, and they're not giving it to her. They're giving her little pieces of the video, little pieces, little sections of the video. What the fuck is that about? What is that? And she says in here, a little bit further along, I think, the audio is missing. That makes me think some of it's from Linda Lane. Because why else is she mentioning specifically audio? What video of a car or any kind of cars being identified is going to have audio associated with it? And why would they retract that audio? And that really makes me think that they don't want people to hear what was going on at Linda Lane during that time. Because we all know, if you listen to Linda Lane, you can hear there's a lot of stuff going on there. There's a lot of stuff going on there. Okay. So the state doesn't want to give her this evidence that they know that they have because they're giving them little pieces of this long. Say it's a 40-minute video and they're like, here's 2 minutes. Here's 2 minutes. Here's 2 minutes. And they retract the audio from it. And she's like, I know you have the whole 40 minutes. Can I just have the whole 40 minutes? They're like, no. And so finally she's like, this is my 5th time. And I'm asking you, like, I'm asking the judge to compel you to give this to me. And now I want a hearing for it. And they want to close the hearing. They don't want the public to see her argue. This woman has to argue to get the state's evidence against her client. How is that fucking normal? In what world is that normal? And how is that fair to her client for it to be closed? What if the evidence is against her client? What if it proves, look, we have it. It says it right here. If it was, you'd think they would have handed it over by now. So by them arguing so much about hiding it, she's not asking to give people's names out. She's not an idiot. In the beginning, the Idaho, we don't want to disclose people's names. Nobody wants the names. People have come up with a lot of names on their own. Trust me. You're worried about names. People have been digging into the whole family histories have been built around this entire town. People have gone back to the roots of Idaho. That shit has been done. Sorry. Ridiculous.
The entirety of the case. And that's what trials are for. I mean, I totally understand that Mr. Kohberger has a constitutional right to a public trial.
Understand that.
But having a hearing is not a trial. That's something different. And so that's why, that's where the balancing comes to. If you want to answer it.
I do, Judge. The Waller versus Georgia case is in the context of a motion to suppress. If the court starts closing hearings now, when the court hasn't closed the other motions to compel, what's the court going to do when it comes time for a motion to suppress? Those are coming. Many of them are coming. We want the hearings in public. The state has dropped bits of information with different filings they've made all throughout the way. This can't be done in private. It just can't.
I would say both sides have said in their motions or their briefs that they've disclosed, certain things.
Okay, I'm
And
stopping. Hold on. Again, with the laughing, both sides have disclosed little pieces. Really, bro? Are you serious right now? The only person that has a right to a fair trial in the room is the defendant. He's the one who has been sitting in a jail for over a year. And your prosecution can't get its shit together enough to hand over the evidence. And so if Ann Taylor can drop little Easter eggs in some of her filings to maybe show the state doesn't have its shit together, good for her. The fact that the state does it, the state's already done it. The state came out of the gate from the jump with the incel and all the other stuff. So stop with the, well, you're both doing it. No, the state has the full weight of the government on its side, the full weight of the University of Idaho on its side. Okay? Bryan Kohberger has no one. He's not even from there. He's got Ann Taylor. And he actually has Eliza Mazoff, sorry if I'm saying your name wrong, and Jay Logston. And I think they're all rock stars personally. Say what you want. And this guy's like, well, you guys both do it. Get the fuck out of here. Get out of here. Sorry. This is why I had to do this, because my head was ready to explode. And she's saying, this is a precedent. You're arguing this is a new precedent to make this hearing sealed, like to close it, is different. It's new, because you're not allowing me to argue why I want this evidence, why it's important. First of all, why isn't he just compelling? Why doesn't he just compel the prosecution to hand it over? Why do they even need a hearing? Why doesn't this guy right here, the judge, say, yo, prosecution, you charged this man. You charged him, right? You put him here. You were hot to do that a year and a half ago. He's in prison. What's up? Where's the evidence? Where's the beef, Bill? Why does he even need why does she have to have a hearing with experts and shit to do this? And so she's going to have a hearing, and they want to put it in private. How is that normal? And how is that constitutional? And how is it fair?
And it's a change, see, that because both sides have agreed to seal a lot of these issues of evidence in the discovery.
Did he
And so all of a sudden it just does feel like it's moving in a different direction. But I understand what you said. It's like, this isn't about the discovery, this is about the hearing.
I don't think you understand it.
Your Honor, those are discovery documents,
Yep.
and there are things in there that the state's chosen to respond to. The state selected which things that we have to have a hearing about. And these are about things that are in the state's possession or control that we want them to give us, and we're asking you to order them to give us these items so that we can do our work, so we can complete our investigation. It's not any different at all. Sealing the documents, I think that needs to continue to happen. That there are a lot of names in those documents and requests for follow-up. We don't have to do that. I do think those are fine, and I think they're different because they're documents that are going to sit in the public record they're different than having a hearing of things that the parties haven't been able to resolve on their own that the court needs to resolve. public has a right to see how its business is carried out. My interest is Bryan's right.
Come on.
But I would ask the court to remember the history. We've had motions to compel 1, 2, and 3 in the public eye. All of a sudden we get to 4 and 5, and we understand the subpart of 5 that has to be in a sealed proceeding. That is going to directly deal with documents the court has ordered be protected. That's completely different than when the state won't give us bits of information that's within their possession and control that we need to prepare our case. Your Honor, I would ask the court to consider too how much pressure there is to get to trial. We've heard the state say they'd be ready by this summer. We've heard the state say they're going to be ready by March of 2025. We've heard them say that they've given us 95% of discovery. We've heard them say they've given us all of the discovery, and those things just aren't true. They're just not true. You can see from the list of things we don't have, there's no way we have 95% of it. So when there's all of that in the public eye and the pressure of let's get to trial, I think the public has a right to see, and Bryan has a right for the public to see that we're trying the best that we can. The court offered to do what it could to speed this up. Having hearings about things that shouldn't be closed, that we object to being closed, takes time. There is no change in our habit or our practice filing documents under seal for things that meet Idaho Court Administrative Rule 32 subsection I, and us asking for a public hearing. There's nothing inconsistent about that, and that's the way we've carried out the case.
Yeah, he's trying to make it look like.
Ms. Taylor. Response, Ms. Jennings.
Yes, Your Honor.
This is so infuriating to me. It's just, first of all, you're tired, Judge. You're conflicted, maybe, because you know this is not right, because you know that this is absolutely not right. See, this is good because I don't know if people will understand this or not. The people that are like, oh, the defense is, they're just trying to delay things. It's all the defense's fault. It's not the defense's fault. When you have to have a hearing to compel evidence against your client, who's delaying shit? And they've had a lot of these hearings. Whenever they have stuff under seal or they're requesting stuff and all these other things, they have to have a hearing about it because Bill has to tell the judge why. Because this judge doesn't go by case law. He doesn't go by case law. And I just want to say, anybody that's following the Karen Reed case right now, that popped off, and I'm putting together a video on opening statements. Anybody that hasn't seen the opening statements, it's insane. But the point I want to make about that is, as much as you might want to say that Judge Beverly Canone is unfair or biased, all of those Karen Reed pretrial hearings were public. They were public, and there was a lot of damning information against the Commonwealth in those pretrial hearings, but none of them were sealed. None of them were sealed. And that stuff implicates people all the way up the chain in the Commonwealth of Massachusetts, including the district attorney, one of the district's attorney. Sorry, I'm all fired up. So like to be like, well, this goes up the chain, this and that. This is a messed up town. This is a messed up place. And what they're doing is wrong. What they're doing is wrong. And whether or not he's innocent or guilty, it doesn't matter. He's been sitting in jail for 1.5 years, and these people still haven't turned over all the evidence. It sucks that they gave up his speedy trial. It sucks. Because honestly, they should have winged it. They should have just winged it because there's no way they would have been ready. There's no way they would have been ready. There's no way. They can't even hand this shit over now.
Ms. Taylor's argued and multiple completely false narratives are the exact reason why this hearing should be closed. Yes, defense has a right to a public trial, but that is not the right to having all hearings open to the public. The court's right. There will be a day for this, and that is the trial. But we shouldn't be discussing all the evidence that we're going to hear at trial prior to that. There's no right to try this case in the media.
It's already been tried. Newsflash. Welcome to a year
The case law that the defense relies upon has not extended this balancing test to these types of hearings. The hearings are about, or the cases are about trial. And yes, they extended it to a suppression hearing, which was so interrelated to the trial. Waller v. Georgia primarily stands for the proposition that any closure, it gives you this balancing test. We just went through the balancing test and the state gave you the reasons for why
An argument.
this meets the test for closing the hearing. As far as being inconsistent, I would just note for the record, we have had one hearing regarding motions to compel. However, at that hearing,
He's like, please save me, save me.
this is your order. At the outset of the hearing, the parties informed the court they had reached agreements on all issues except request 160. We discussed one request and it had to do with training records. That is not what we're contemplating discussing at this hearing on the 14th.
It doesn't matter.
I've gone through the multiple issues and subparts, as well as the reasons why we cannot have this discussion in an open forum.
Thank you. Want to respond to any on that?
Yes,
Ms. Taylor?
Well, Your Honor, we had the entire IGG state's motion for protective order and our objection to that in a public forum as well. That ends up resulting in us receiving documents that the court had a protective order on, and we can't even share with our investigators that come to court with us. And we've abided by that, and we understand that. But the entire hearing leading up to that was done in the public eye. In that particular hearing, they talked a lot about DNA results on a knife sheet that I'm sure benefited the state to have that in the public eye. What we're going to talk about on the 14th, Judge, I don't have to name any private citizen names.
Do it. No, not the.
I can talk about records that exist and why we should have them without naming private citizen names. I can talk about the videos that they've not given us. They're not about the business. They're about videos that were collected by the police. I can talk about those in the context of the police reports. And by the way, those are all things that are talked about in the probable cause affidavit. And I can talk a ton about the cell phone information, the cell tower information, and the things that they have not given us, the drive test information, the verification of.
That's the thing. I don't want to talk about those particularly.
Really?
And
why not?
I guess I'm reminded, okay, in your comment about the IDG, because once again, I'm in this position where I have to make decisions blindly to some degree, and that's what the case with the IDG. I mean, I had to go through all of that information, and then I provided most of the information to you, okay, to the defense, so that you could evaluate that.
Wow.
I feel that the same way about there's a lot of stuff, okay, that you're arguing about, and the state is arguing about, and I think it's complicated to just open that up. I think that, maybe we could go through a closed hearing,
of course,
and then open up what you feel needs to be opened up. But I can't make that decision in the
we don't trust you, Ann.
So that's my worry, because I went through all this last night again, and I thought, how do we really fairly deal with each one of those issues? There are a lot of issues.
I agree with you. There are a lot of issues. I would ask you to look at the probable cause affidavit and read the parts where they talk about relying on FBI agents and the CAST report and different cell tower data. Your Honor, that stuff's in the public eye. Why can't I talk about what they refuse to give me in the public eye?
Well, one of the things that we want to talk about today is I just got motions for subpoenas, duces taken to the FBI. I mean, it's really difficult to get information from the FBI. You know that. They know that. I know
A
that.
year and a half
We
later,
have we have to jump through a bunch of
I don't
hoops
believe it.
to get particular information from the FBI. That is not the state's issue, although maybe it should have happened 6 months ago.
That's the state's issue.
I understand that,
Issue.
but
Hear how I'm gonna tell you something. This woman right here, I give her a lot of credit. I don't know if she goes home and funnels vodka or does yoga or I don't know, something. But for him to say what he just said, first of all, he doesn't answer her questions. He directs into something else, tries to turn stuff back around on her that she's doing that's appropriate. It's all word salad. And just here, just now, you know how hard it is to get things from the FBI, right? It's been 6 months. Although the state maybe should have tried sooner. He says it's not the state's fault, although no, it is the state's fault. It is the state's fault. It's the state's fault. So I call bullshit on this. I call such bullshit on this. It's so bad. This is starting to go Delphi. I mean, this is ridiculous. This is so ridiculous. And this judge really makes me angry. And I don't like to criticize people like this typically, but he's not this dumb. And if this case is so complicated and there's all these moving parts, then maybe they should just move it to a federal court if it's that serious. Because he doesn't seem to be able to handle it. It's so complicated to him. You're a judge. That's your job, to make decisions like this. He was proud of himself that he was able to make a decision and then help them out. Bro, that's what you're supposed to do. You're a judge, right? Like, isn't that what your job is as a judge, to make decisions?
that is one of the things that, I mean, we can maybe address that today too. I'm thinking that you don't have an objection for me to sign the subpoenas.
Sarcasm.
No, Your Honor, I don't have an objection for the court to sign the subpoenas to try to get the information.
So I can sign that today.
You can sign that. You can sign that. Anything you need to sign to get us the things we want, please sign.
I'm with you. I'm trying to do that, and
I don't think
but
from what I've seen, I mean, I think the state is trying to do that. I know that it's not satisfactory from your position, but there's a lot of issues in this case.
And Your Honor, that's really a lot of what we're going to talk about on the 14th is the timing of these things,
Right.
Not the full content of what we think these things might show. We don't know. We don't have them.
Right.
They know.
Likewise.
So I think the timing is important. Your Honor knows how much pressure there is to get this case to trial, and Your Honor also is aware of all the things that we have to do. And when we make a request and months later, you're asked to sign the order so that maybe we can finally get that information, that timing part is important for the public to know. That's not the content. I'm not going to talk about the content of that subpoena you just brought up. I don't need to talk about that at all. But I can talk about the delay in this and why there's a delay in us being ready for trial.
For it.
That is fair game for the public, and that is something Bryan has an interest in having public. So I don't have to talk about that content. That's not the issue at all. But the things that are laid out in the probable cause affidavit that has been on the court's public website for a year and a half now, it makes no sense that I can't ask for those things in the public when there are things that the state said they relied on.
Ask to the fire.
That just makes no sense. I have one more ask when we're done with this issue.
Happy to throw
Thank
her
you.
out there.
I mean, are you expecting to make a decision right now? Maybe
Oh my
not.
God.
Well, Judge, you should just make the decision to have the hearing open. And if I start to talk about content, then maybe you can talk about it then. I don't agree any part of it should be closed. I don't agree any part of the hearing should be closed, and I think you should make the decision now. We're 2 weeks away from this hearing.
Right.
Or 2 weeks, is that right? 4 days?
We're less than 2 weeks. We're 12 days.
All right, well, I kind of mentioned this a moment ago. I just feel like we need to get into the details, okay, of all these issues before I open it up. So I'm gonna close that hearing.
Yeah, of course he is.
Now, that doesn't mean
He's going to close it. Why? Because there's so again, what's the hearing about? This is insane to me. She is, for the 4th time, I think, or maybe 5th, asking this judge to basically compel the prosecution to hand over their evidence against her client. Why they need a hearing to do that is beyond me. I would think that you just hand the shit over, or you get sanctions or whatever they do to attorneys that don't do what they're supposed to do, right? Why you need to discuss it, I have no idea. This guy is so willy-nilly noodly. It's so annoying. But okay, fine. So you want to have a hearing about it. But we are going to, we have to we have to do it behind closed doors because we want to protect Bryan's rights. Get the fudge out of here. You could care less about his rights. He's been sitting in jail for over 1.5 years. You don't care about his rights. You don't want people to know that it's your fault the trial's been delayed. You want to keep blaming the defense and Ann Taylor and all this other stuff, that it's all their fault because he's guilty and he doesn't want people to know and this and that. To the point where this woman went out. They went out and they hired their own expert to show that he wasn't someplace that you said he was based on cell phone tower data that you didn't give them. That's in your own PCA. And then people want to shit all over Cy Ray or whatever his name is. Come on. Do you care about people's rights at all? Do you see what she had to do just to get this going? This is absolutely insane to me.
that after we sort out all of those issues and I have more
Can't stand it.
understanding of why you aren't getting what you want or what you asked
How
for,
difficult is that conversation?
or whether or not
How
there
hard
is
can that be?
something that you've asked for that doesn't exist, or that some of
There's a
the
problem.
materials are holding with the FBI, and that we need to get that. I mean, those are all really complicated processes.
It's not complicated.
And I would feel much more comfortable when,
Behind closed
again, I'm trying to protect a fair public trial and
A fair
not
trial for
have
who?
a maybe not intentional, unfair hearing, okay, that goes out to the public. I think that's the balance for
But you
me.
don't want to look bad.
And I want
You wanna
to
look bad?
see what all the issues are, the arguments from both sides, so that I can make a more
People
informed
suck.
decision. So I'm going to close the hearing. At some point in that hearing, maybe we can open up part of it.
Yeah.
But I need to dig in, and you all need to dig in to exactly what is the problem with each one of these.
I think everybody
issues.
should know what the problem is by now.
All right, so let's talk about the schedule. Okay, the state asked for this, some disclosures of witnesses, expert witnesses, exhibits by May 3rd. I don't think that's particularly practical at this moment. I know that you had, and I'm not looking at it right now, you got another idea about that, Ms. Taylor?
Judge, I think I had May 7th.
Okay. That seems more practical. Okay, so I will add and put an order out, schedule order for providing. I don't know if the state really knows what you do until you see what they have.
What?
And you're shaking your head, yes.
Yes, sir.
What?
And that means that maybe you don't have any witnesses, expert reports, or exhibits at this point because you don't know what to expect.
Right.
And this is
Oh,
related to the hearing on the 16th, right?
In the 14th, I'm not sure.
Okay. And there may be witnesses on the 14th too, as well?
Yes, Your Honor.
Okay. All right, so let's make it May 7th. For disclosing witnesses, expert
Whatever.
reports and exhibits. We'll see what the state has to do with that. And we'll have a response maybe May 10. Is that
That's fine.
sufficient? It's tight.
Well, that gives us 3 days to respond.
3 days.
You can handle it.
Yeah, that's right. Well, May 10 is I don't know when I'm gonna read all this stuff too, because it's 14th, so if I don't have it by the 10th, then you're saying the 13th. I guess I can do that the night of the 13th.
Yeah, you can do it.
But also, the defense needs some space there too. And I don't think we want to push out that hearing.
She's not going to agree to pushing anything out.
Can't do it by the 10th.
I wouldn't.
We have no idea what the defense plans on doing, and that only gives us 3 days to read, comprehend, and respond.
We'll deal with it.
They have no, let me just, you know what, I get it. I'm just gonna say this. I know I'm not an attorney, right? And I'll probably watch an attorney later and they'll explain all this and I'll feel like an idiot, but I don't care. So I'm just gonna go based on like just common sense and common, like what you would think would make sense, right? So now we're having a hearing that's closed to the public to compel the judge to make the judge compel the prosecution to give evidence that's in their PCA that they used to arrest her client. Okay. And she's bringing experts, I guess, to show why there shouldn't be any delay or something and how she knows this stuff exists, right? And the defense is upset because they only have 3 days to prepare for it. And they don't know what they're going to say. Because you should be scared. You should be shitting your pants because it sounds like you don't have much of a case. If you have a case, then there's nothing to worry about. There's nothing to, like, what is the issue? She has to bring witnesses to argue this judge to compel you to give evidence in the PCA that you used to arrest this man, and you're worried and you need more time. Why did you arrest him when you did? I don't get it. Am I missing something? Yeah, and Bill Thompson doesn't want to be embarrassed again. He was so upset, right, last time with the surveys. See, that's what happened last time. We had the boss come in, Eliza, and cleaned up the floor with them. And God, I hope she comes in for that closed hearing and mops their asses up. And Bill Thompson didn't like the fact that he had an expert. They wish they had an expert to dispute that guy. That those surveys happen on any high-profile case. He's still pissed off about those surveys. And then at the end, it may show that the other counties are just as biased, so they can't move anyway, and it doesn't matter. It's ridiculous.
We'll deal with the 13th then.
Yeah, I mean, we can try, and then if we
Okay.
need more time, we'll ask for more time.
You got to go.
It's just then on my end, you're looking at, I'm gonna have really more, I'm gonna need more time.
Your Honor, I don't expect reports. I expect to provide a witness list.
Okay,
I don't expect there to be reports.
Love it.
exhibits.
Sit your
There may be
pants down.
exhibits. I think there will be at least 2 or 3. I know some will be things that they've already given us in discovery, so they shouldn't be new and surprising.
Okay. I mean, it's hard to have these tight, timeframes because
Now, look at him standing up with
we
the
also have other things to do, but
witnesses.
Mr. Thompson?
Your Honor, it's completely unfair and unacceptable for us to get a list of witnesses with no idea what they're going to testify about. Names witnesses don't mean much of anything. And unfortunately, we're having a pattern in this case of last minute disclosures of witnesses and PowerPoints and all sorts of things that frustrate Your Honor's ability to assess what's going on because it's brand new to you, just like it's brand new to us. And I think that practice has to stop. We need substantive disclosures. If they're offering experts, the rules of discovery specify what you have to disclose regarding an expert, and that's not just a name.
Wait, I'm sorry if you probably hate me if you're just watching this for the first time, but can we all just take a minute to appreciate what this man is arguing about? She is trying to get discovery that he used that's in their PCA that they used against her client to arrest him and put him in jail for the past 1.5 years. She has tried to compel this judge to get these people to hand it over 4 times. He won't just order it. He wants a hearing. So she's going to bring witnesses, and that made him stand up and put his arms like, and this is just not fair, and this is just blah, 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 blah. Dude, are you kidding me right now? Are you kidding me right now? God bless Ann Taylor. I'm telling you, she's funneling vodka right now if she drinks. And if not, I hope she does. I hope she's doing yoga or something healthy. This guy.
What's being propounded by the defendant right now simply isn't within the rule. It's not appropriate. It's not fair to the court or to the state.
Okay, well, I mean, you don't have to have witnesses or exhibits, but you can have a response to say, well, this isn't fair, or whatever you want to say. Otherwise, I just need to push out this hearing. I'm stuck.
I appreciate that, Judge, and
This is ridiculous.
I guess we've said it before. It is more important to do it right than to do it quickly.
No,
We have to have a trade-off here,
no,
and that includes fairness to everybody involved, including the court.
no. He's the only one.
And I would prefer that this not be kicked off, but we're realizing that we're 2 weeks, essentially 2 weeks or less away from these hearings, that apparently there are going to be a number of witnesses.
Oh, well.
Nobody but the defendant knows who they're going to be and what they're going to try to say, and then we're expected to react in court. That's just simply not the way to operate an effective, efficient, fair process.
For who?
Well,
You want to put
let's
him in jail.
explore this. I mean, how many witnesses are you expecting to have?
Your Honor, I'm expecting to have 2 on the 16th at this point in time. I'm not expecting either one of them to write a report. I expect a couple of exhibits. Some will be things from the protected materials that the court allowed us to have already. There will probably be 1 or 2 other exhibits, maybe 2 that the state hasn't seen before. I can provide those. I intend to provide those. On the hearing on the 14th, I think there may be 2 witnesses on that hearing, 1 for sure, possibly a second. We haven't made that determination yet. If there is going to be any PowerPoint presentation, I will provide that to the state as well. if we have an expert who hasn't written a report, then we won't offer expert opinions. We'll offer opinions about why we know the discovery is available, why we know these items are available. The state knows full well what they have and what they're withholding from us. And that's, I mean, it's not going to be about what they're going to show. We don't know what they're going to show, but we know they exist.
Yep.
Thank you.
What is, oh my God, this is
Well,
unbelievable.
I just want to have this hearing. And this, I don't want to push it out. All I can say is do your best. I'll be fair about it. I'll give you more time
No
to
more.
respond if you don't have that time. That's kind of where we are. And I just want to keep going. I mean, we got to get through all this discovery stuff
Sit down, toddler.
so that we can get ready for the trial.
Yeah.
Well, and Judge, I do for the record need to clarify, the representations of the defense that we are intentionally withholding things that they're entitled to is just utter nonsense. We have strived, we are continuing every week to provide additional discovery. We have more discovery coming. We hope that much of what they felt they had to file a motion to compel on, instead of being patient and wait, because our discovery deadline isn't until September, that we'll have and be able to make that available between now and the hearings on the 14th. And there may very well be little, if anything, we have to fight about. Your Honor also noted there are some things that we simply do not have the power to access. And we have been trying consistently through cooperative efforts, as well as following the process with the federal government. They have been good partners, but they have their own rules to work with. This isn't the motions for the subpoenas ducis tecum isn't the first TUI process, and the court is aware. We've been pursuing TUI process for all types of information for months. So the characterization that we are just consciously withholding information to frustrate the defense is utter nonsense. That is not true. We will provide everything we can that is providable under the rules. If we disagree on something, whether it exists or not, because I can tell you, many of the things that the defendant has tried to itemize, when we talk to our people, they say that doesn't exist. So, I don't know what we're supposed to do at that point. We'll flesh it out at a hearing. And it may be that if they have experts who are going to say, well, such and such should exist, we might have to go find experts to say, well, in this case, it doesn't. Or no, we'll see.
Well, that's exactly why I want to close it on the 14th, because we're going to have many arguments, apparently, about issue by issue by issue. And some of that should not be out of it.
Thank you, Your Honor.
Because what the hell is
Your
it?
Honor, I want to respond to that.
Thank
And I
you.
can give you particular examples of things. And it's already been ordered to be given to us, the CAST report, which was a draft that we were promised to have by March 31st. It's May 2nd. We don't have it. So for the prosecutor to stand up and say that I'm misrepresenting things, he's misrepresenting things.
Thank
Your Honor.
you.
That's
You know
there.
what? Let's not go there. I mean, we can sort that out on the 14th. I mean, I read everything. That's what the state was saying. I trust both of you, okay, your integrity. So I don't want this pointing the fingers back and forth. I don't think it's very helpful. Doesn't really help me. It started with the last hearing, and I really want you all to just tone it down a little bit. I mean, you can argue all you want, but when it starts to be personal, it's destructive. I mean, you're really, really good lawyers. So let's just focus on the issues. That's
Your Honor, we're happy to. And when we get the CAST report, we'll disclose it. If we do not have it, we are not withholding it. As simple as
I
that.
read that last night. Okay. I'm fairly prepared about what the issues are, okay, about the discovery. And that's why I want to be able to
hear from both sides, okay, what is the problem with this? What do we need to go forward? And I'm going to try and help that. And I expect that both of
A
you
year and a half,
do the same.
no cast.
Your Honor, I do have several other examples, but in light of what the court said, I won't provide them right at the moment.
Good for you, girl.
There are other issues.
I understand.
For you,
And I
girl.
understand your frustration. And it's a big deal. It's
It is a
really
big
important. I understand that too, and I acknowledge that. Sometimes, we just can't quite get what we want from other people who might have it that don't want to give it up. So
Yep.
that's one of my challenges on the 14th and probably at the 16th too. Okay. Moving on. We've got all right, some of these pending motions, there was no request or no response from the state. And I'm thinking that the motion to unseal parts of the IDP materials and motion to allow defense investigators to review the IDD materials that we're going to be addressing that on the 16th. Is that?
Yes, sir.
That's the state's understanding. Is there?
Yes, Your Honor. Well, we're happy to have a hearing on the 16th for both of those issues as well.
Great. I'm just trying to make sure that we're all on the same page, or at least the same date. But I wondered, okay, there's been a response on the alibi issue, and I don't know if there is a request for a hearing, or if we just kind of let that lie for now. I don't know. What was your intention there, Mr. Thompson?
I think at some point we're going to need a hearing on it. We're busy enough for the next couple of weeks with these other hearings, so we haven't reached out specifically on that.
Okay.
If the court would like to select a date while we're together today for a hearing, we would be happy to.
Why don't we just wait
that
until the 14th or 16th?
That's fine.
And there may be issues that come out of discovery that have some bearing on that issue. I don't know. You don't have to say anything. It can read your mind sometimes, maybe not. All right. Okay, I'm going to sign those subpoena duces taken. The FBI. I believe that's related also to the 13th supplemental. Maybe I'm kind of losing track.
Your Honor,
Well,
it does relate to one of our discovery requests, and I'm sure one of the numbered motions to compel. I'll note that when I speak about that on the 14th.
Okay, great. All right. Are there any other issues that we need to address today? Mr. Thompson, Ms. Jennings? Okay, Ms. Taylor?
Yes, Your Honor.
Okay, go ahead.
I want to say this in a way that doesn't come off finger pointing, because it's not. This is about how busy everybody is and how much time it takes to communicate to get hearings set, because there's a lot of people going a lot of directions. I would like the court to consider setting hearings twice a month, every other week, and the court could vacate those hearings if neither party notices something up for that hearing. There would be 14 days notice for either party if we have hearings on that basis. But that way we could notice up specific hearings and just have those set dates so that we're not bugging the prosecutor's office for a stipulation and bugging the clerk's office for a hearing and waiting to find that out. It would speed things up to have 2 times a month that we would know if I've got 14 days before this hearing, I can notice it up and it can be heard by the court. So that's our request, is that the court just reset a couple of hearings. These would not be like the lengthy motions to suppress that we'll probably need a couple of full days for. These would be these shorter motions that we could deal with in 1 to 2 hours.
All right, thank you. I actually mentioned that, I don't know, one of our hearings. That's what we need to do. I think it would be more helpful to, I guess, have better communication, okay? I don't know, maybe you are having good communication, with each side. It is hard, to get a hearing when the clerk has to contact you or contact Mr. Thompson, and it just goes back and forth. I mean, it takes a lot of time for your assistant, the clerks. At the same time, I have a lot of other cases, and I have a lot of jury trials going from here really to the end of the year. So it's hard for me to say, okay, we're gonna have it I think I offered Thursday, like a Thursday afternoon. So I'm willing to do that. I might just set like once a month, maybe, and then if you need something more, just let us know. But I'll look at my calendar and set that up. I mean, I know you come down on Thursdays generally. So that's a good day for you, right?
Thursdays are fine, Tuesdays are fine, Fridays are fine. Wednesdays are rough, but whatever day works for the court, I'll make that work. I just think it's more important that we have a place to put these hearings so that everybody's not spending a lot of time asking each other what day's okay, what time's okay, that we just all know that this is the time. So whatever day works best with the court schedule, Your Honor, is just fine for me.
Thursday afternoon is probably,
That'll work.
Monday is impossible. So what do you think about that, Ms. Jennings?
Yeah, that makes sense. I think Thursday afternoon be fine for the state.
Do you think twice a month? It's probably gonna ramp up.
I suggested that just because then there's 14 days to the next hearing, so everybody would always have enough notice. This is why I suggested that, and to know that we have those to iron out issues that are going to arise. Again, these aren't for the motions to suppress, those will come later.
Maybe we'll start with twice a month to get through all this discovery. I mean, I hope we can all get past that soon. And move forward a little faster. Okay, anything else then?
No, thank you.
Okay. Okay, great. Well, thank you all, and have a good day. Beautiful day. Thank you.
Okay, so that was that was me just reacting live to that. My head was exploding. Normally I'm a little more giving more grace. So I might have been a little hypercritical of the judge. Maybe he's just a really nice guy and he's caught being a judge in a really crappy situation. But it just seems like he's not able to make decisive decisions. And I'm going to bring up Beverly Canone again, Judge Beverly Canone. I know she got a lot of grief. I've been following the Karen Reed trial, and if you haven't followed it, you should check it out. I'm going to try to get up to Boston. I won't be able to sit in the court. I did apply for a press pass, but they don't consider YouTube news, which isn't surprising. But they're in that little postage stamp of a room that they probably tried women as witches back in the day. It's like from 1831. But she can be kind of sharp, and she sighs a lot, and she does seem to be a little nicer to the prosecution. but she relies a lot on case law, and she is sharp. And this judge just doesn't seem very sharp. And when she was bringing up the case law, it's like he's not going to look up the case law for this decision. He's more concerned about Bill Thompson having a conniption. It just that's my impression. And I'm not a lawyer, like I said, obviously, and I'll probably watch Andrea Burkhart's account of this and feel like a total idiot because I misread everything. But it just doesn't seem right. Like, I just don't understand the process of a hearing for a motion to compel, and then Bill Thompson getting upset about her bringing witnesses to prove the fact that you should have this. And the fact that they don't have the CAS data from the cell phone, this is so confusing to me, because I did a video on my channel, like, I don't know, a few days ago, within the past week. The government has equipment. And we saw it with Google, but I don't know if that's legal. But the government has equipment. You don't even need a warrant for it. It's like a little machine. They take your phone and they stick it in the machine, and in minutes they extract all this data, and it gives them all kinds of information about you. And it's really scary, and they don't need a warrant. So you should never give them your phone, even to check one thing, because they can do that and download it all. And that would give all of his data location. And so for them to say they still don't have the cast information, does that mean that the Moscow Police Department doesn't have one of these data extraction tools for cell phones? I'd be curious to know if they do. And if they do, does theirs take over a year to extract the data? I'm confused. That doesn't make sense to me. And that's probably what doesn't make sense to Anne, right? So, if they had to have prosecuted other cases where they've used cast information, and these things don't take over a year to get back. And I mentioned it in a comment somewhere, but the defendant himself could, if it's an iPhone, you give your login, and she could log in and get the information herself. If he's innocent, he could do that. If it's an Android, there's also ways you can do that, right? He doesn't have to show anything, though. The state has to show something, but they're not showing anything. They keep saying they don't have it, which is why it's too bad that he just didn't do a speedy trial, because it's clear that they don't have any. They don't have their shit together. They mentioned a drive test. I don't know what a drive test is. I'm really curious. Does that mean, can you get from point A to point B and then do something inside and still manage all this stuff? Is that what a drive test is? I have no idea. I'm going to Google it later. And a TUI process. TUI process, I know from the Karen Reed trial as well. Karen Reed trial, the federal government, FBI, and the United States Attorney General is investigating the people who investigated John O'Keefe's murder, which isn't really good. The state decided to take it to trial anyway. It's a shit show. But I know that they used a TUI process there. Does that mean that the federal government is somehow involved in this case? The fact that they mentioned a TUI process, again, I have to look that up because I'm not sure. But the other thing she mentioned that they haven't turned over, the cell phone, the tower info, the CAS system, the full videotape. The videotape they did give doesn't have audio. That brings up Linda Lane for me. I don't know what other videotape with the car on it where audio would be retracted that would be important. That's really interesting. And she has every reason to be pissed too. They from the jump painted stalker on social media. The gag order has done nothing but hurt her client. The state's already got their narrative out there. They're pissed because it just got slammed, with that last hearing. And people like, Nancy Grace and mainstream media are still not acknowledging the fact that shit's not real anymore. So what do they really have on him? The sighting of this car, a white sedan? Okay, but they won't even give her the full video. And so really what it comes down to is the DNA, the touch DNA, which I'm not going to get into it. I can't do it. I can't. I've never done a video on it. I don't know if I'll ever be able to, because it's too much. It's just too much. But at the end of the day, if that's all they really have, That's really lame. That's really lame. Especially for something like this. You think they'd have a shit ton. So, anyway, if you watched all this with me, I appreciate it. And I will be back. Thanks, guys. Bye.